NACDL is the association of the nation's criminal defense bar.
You got to be funny, and I'm going to talk about being funny. Not every case is funny. I get it. You don't want to stand up from the very get-go and make a joke if you have a child abuse resulting in death. That's not appropriate. I understand that, but we're going to talk about in your cases where you can actually be funny. So, Rule 24. Every state has a different jury trial rule, but most states, except Louisiana, because I practice in Louisiana, we got the Napoleonic Code down there. Brady, I don't even know what it's modeled after down there. It's just modeled after fuck you is what it's modeled after. But most states are Rule 24, and most states are modeled after Rule 24. So when you go to court, I know this sounds fundamental to most of you, but look at the rules. The rules of evidence are like your Bible, honestly. And every single trial, no matter how many I have tried, and I've tried up to almost 200 jury trials in my lifetime, and I don't know if a lot of young lawyers are going to ever get there because of the trial penalty, meaning most people aren't going to trial because the penalty is so great that we don't challenge those constitutional rights that we have. So I don't know. I don't know if people are going to be able to do that. But remember, look at your rules of evidence, because I cannot tell you how every time I have a trial, I go, oh, that's right, that rule, 619. Oh, that's right, 702 does say this. So it's just as good to refresh your memory. Look at Rule 24. Have it on your sticky, so when the judge is saying to you or you get challenged on a preemptory cause, you know what the heck to answer back with. You got the rule in front of you, and hopefully you also have the case that supports your position. Right? Because that's how you get credibility with the court, and that's how you get credibility with everything that you're doing in there. So you want to make sure that you got the rule down, right? So here's, I come to you, and Martine was talking about the degradation of democracy, and this morning is kind of a scary morning when you wake up and you see that Putin wants to go back to before the Cold War, you know? I mean, it's kind of a scary place for us. And so it's scary for us as trial lawyers. Preemptory challenges have been eradicated in the state of Arizona. You don't get them anymore. They're gone. Interesting, right? And what, anybody here from Arizona? Okay, you're going to have to tell me all day long why the defense bar supported that eradication. There's nothing you can do or say to convince me that is right. Because I'm telling you where this is going with the eradication of preemptory challenges, and this is going to be a movement. I foresee this coming across the country. It's because it will not allow you to drill down on the things you need to know about your jurors. You will not have a diverse jury, because guess what? If you don't have preemptories, then you get challenges for cause. And you know where that goes. And so getting rid of preemptory challenges is very scary to me. But that's what they're doing in Arizona, and states are watching to see what's going to happen. That's both in the civil cases and criminal cases. And you all in Arizona, you're going to have to tell me how that goes. We're keeping track of that. So, you know, they've been around since the 19th century, and they're a holdover from, you know, British law. Now, you know, there's some things from British law, colonialism, that I'm not going to be so excited about. But this is something that has come down from British law, and I really actually think it's important that we stay on top of this. So, the reason that the Arizona folks say they got rid of preemptories is that it points to this widespread race-based discrimination. It's a fact that people of color are disproportionately eliminated from jury pools. You all know that, right? You know that. And frankly, we're doing a piss-poor job of protecting jurors of color from staying on juries. We kind of just let it go. You know, when a juror of color says they have negative feelings about law enforcement, we just go, oh, we're going to lose that juror. Instead of protecting or isolating and insulating those jurors, we just let it go. And so it's very, very, very difficult, and I'm not going to go into Batson, but it's notoriously difficult to enforce Batson. And you know why we know that? In the state of Arizona, there were 2 cases out of like 87 that were withheld because the defense lawyer made the good record on Batson. So it just doesn't get enforced. It doesn't get enforced because we're not in there making the record, and Martine's going to talk about all that. But I'm telling you, this is really, it's scary stuff for us. So here are the themes of voir dire that most people come from. And there may be some out there that I've missed, but this is normally what people think about. So most people say when they're doing voir dire, it's to educate or change the jurors' minds about something. People believe that. That's old school, I will tell you. That's old school voir dire where you had lawyers getting up and saying, you understand that my client is presumed to be innocent, Mrs. Smith. And Mrs. Smith, as you look at my client today, you understand there's no evidence, and you agree that the government hasn't done anything. And you're going to follow the courts, the law, and the presumption of innocence. And they have these very flowery things, and the jurors are sitting there, and they're agreeing, they're nodding their heads. Nobody's really saying anything. There's not a disagreement, and everybody just goes along with it. That's the educating. And what we know is you cannot educate or change jurors' minds. It's just like politics. You think you can educate or change folks who believe the mask should never have been worn? We know that we're divided. They've made up their minds. You either believe in the science or you don't believe in the science. Are you going to change their minds? Did you get there at Thanksgiving with your family? You changed their minds? Of course you didn't. Okay? So it's the same with jurors. Just because you come into the courtroom, these people don't change. And so one of the things we know is educating jurors, you got to get rid of. You got to get rid of that, okay? Get that out of your mind. How about profiles? Anybody work with profiling jurors before they come in? So sometimes we get information about our jurors in advance. Sometimes judges, it depends on the jurisdiction, depends on the kind of case, a murder case, a child sex case, oftentimes you will get that information in advance. Sometimes we're in court and you just get it, right? You get the questionnaire or whatever, and you're going quickly and you're trying to make it through. And I know that. I know that anxiety. But sometimes you get that information in advance. Oftentimes, we have a profile of jurors that we want. So you say to yourself, okay, I have a fraud case. I want someone who, looks like this. They're Republican, they're male, they're 32 to 45. Whatever factors that you come up with that you think are consistent to the theory of your case, meaning that profile of juror has an open mind to the theory of your case. That's what your profile should look like. When you do profiles, you have to be so very careful. Now, in this day and age, you got the internet. And you should have someone in there, if it's just you doing the case, have a law clerk, have a law student, have a college student, whoever, and they should be on that computer, Facebook and Instagram and LinkedIn, whatever it is, bam, 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 bam. It's legal, it's ethical, and many courts say you have an obligation as a defense lawyer to be doing that, to be vetting that. And you ought to. It's super easy. I don't care if you have internet in your courtroom or not. You can get a hotspot. Super easy to do. But that's the easiest work to do, to vet those jurors, because I'm telling you what, the profile that you think you might have may be very inconsistent with what's on their social media. Think about your own social media. Are there things on there that might be inconsistent with how I look at you right now? You're nodding no. You are who you are. Most people aren't. Trust me, okay? Most people got something out there that's going to make a difference to me in terms of my theory of the case. So, deselect. This is where we are. And this is where we have been for many, many years. So my mentor is in the very back, Dr. Sunwolf, who's going to talk to you later today. Everything I learned about my instincts about jury selection come from Dr. Sunwolf and my mother, honestly. Everything else is, I've been educated on it, but it is the things that I have learned that I know are true. Deselection, because I come from the Colorado State Public Defender System, we've been doing it for many, many, many years. Now it's in vogue. The plaintiff's bar took it. David Ball started with it. He gives Sunwolf a little bit of acknowledgement there, but that's where it comes from. It's this idea of eliminating jurors, not selecting, not picking, not trying to change your mind that you need to be on my jury, but I'm getting rid of jurors who I know are never going to have an open mind to my theory of the case. Period. Super easy to do. It's so great when you do it, but I'll tell you where it is different from old school. You don't feel so great when you sit down next to your client because you have found out all the jurors who are not going to be good for you. So in the old school, when I first started picking jurors, I remember you'd sit down and you were like on fire, This is the best part of a trial. And you're talking to the jurors and they're talking to you, and you sit down, you look at your paper. And I remember as a young lawyer going, okay, I don't really know who I like and don't like, but they like me, and I was on a roll because they were talking to me. But I didn't really figure out who to deselect. Now, I won cases, even then, but probably had nothing to do with my jury selection, okay? Now when I got much more schooled on it and learned a lot more about it, I knew that I was winning those hard, awful cases where a lot of the facts, anybody have those, are against me, and I was winning them anyway. And a lot of it had to do with deselection. Now, there are jurisdictions in federal court where we don't get to pick juries. We don't get to talk to the jurors. It's frustrating as hell. I will tell you, though, don't give up the fight, because if you can prove to a federal judge or a judge in your jurisdiction, this is why I need 5 or 10 minutes, judge. Let me make an offer of proof as to the question I need to ask and find out that attitude. Oftentimes, they'll let you do it. They'll let you have 5 to 10 minutes. I've had federal judges give me time. Okay, so don't give up. Yes, you can do a juror questionnaire. It's hard to deselect with a juror questionnaire. You can do it, but make sure you're filing the motion and asking for that attorney-conducted voir dire. Okay, so this is what we know. We got to get fair-minded jurors. So it starts before you get the jurors in the seats, okay? So here's what I think we often forget, is connecting with the jurors from the minute we enter the courthouse. Okay, so here's what happens to us. We're in this thing, we're in our heads, and we're like ready to go to trial, or I'm there every day as a public defender. And I forget that the minute I'm in the courtroom, coming through those gates, coming through the security system, I got jurors. I got folks who are going to be on my panel. So the way that I'm acting, if I'm being a jackass with the security because I'm pissed because you know who I am, and again, you're making me take off my shoes and open my briefcase or whatever it is at your security. Anybody ever, you're like, come on, you know me, I'm in a rush. Those jurors see that. They see that status way that you're acting with someone else. They're not going to forget that just because you might be likable in the courtroom, okay? So connection starts early. It starts when you get to the courtroom. You know how they're all lined up outside the courtroom, right? They're waiting to come in. They're not happy. Most of them don't want to be there. They think the process just is awful. You got to pay attention. Pay attention to what they're doing. Is there a leader? Is there someone in the middle talking about what's going to go on? Pay attention and connect. Smile. You're not allowed to talk to them, I get to it, but there are other things that you can do to make that connection, and you got to do it early on. Don't forget about that. Connect during the judge's introduction. The judge is doing introduction. The judge is reading all the 72 counts against your client. You're putting your head down, writing notes as if you don't know what your client's charged with, okay? You're hiding, and you're not connecting with the jury while the judge is reading. I get it, but those moments matter. And you can't forget about that. You got to look them straight in the eye. You got to have your client sitting next to you or whatever it is, putting your arm around them or whatever might be appropriate, but let the jury see early on. Because how many of you have heard about primacy and recency? We hear about it all the time. Of course we do. What we do first, what we do last matters. To me, this connection is primacy. That is primacy. It's not just when you get up to talk. So you have to make sure, even during those introductory remarks, that you're doing what you need to be doing. This is not connecting. Standing up there with a scowl on your face with your clipboard or your iPad or whatever it is, and like taking notes while each juror is talking. Like, really? What are you taking notes about? What are you doing? Minus, plus? That person gets a 5, someone gets an 8? What if someone said, can I look at that? What's going on? You're just scribbling most of the time. I mean, I know that because you just don't know what to do instead of connecting with that juror. All right, and particularly during the government's voir dire, make that connection. The government's voir dire, it's always hard, right? Because you want to make faces, you want to laugh, you want to scowl. I get it. But there are other ways to connect that may not be in such a negative way. Sometimes, I mean, look, if the government's saying something super inappropriate, you may want to get kind of a disbelief, like, gosh, what is that about? You can do that, but make sure it's appropriate and not overboard, okay? You don't want to go too far on that, so have balance. Okay, and being funny, this is what I love. So I put Larry David up here, and, you know, apparently he's hilarious. When I watch it, it's very difficult. My husband and my son love Larry David. They love it. They think he's funny. They think he's great. He's super smart. I find it painful. Everything he does is so painful to me, but that's me, okay? Something must be wrong with me. So, but most people like it. But here's the message that I want here is that what they're saying is people who share a laugh together are more willing and comfortable to disclose. That's social science. That makes sense, right? If I'm laughing with you, I'm more comfortable. Now, I don't want you laughing at me. Well, maybe you can laugh at me. Maybe there are things that you can laugh at me about, but sharing that laugh is really important. So don't be so serious about everything that you can't make that connection. Okay, so what are we doing in jury selection? We're asking to identify problem jurors. We're asking to maximize honesty and openness. We're looking for strikes for cause. You got to always keep that, and someone else is going to talk to you about strikes for cause and how to voir dire for racial bias, and Martina's going to talk to you about that. Jurors' behaviors, not their beliefs, matter. This is, to me, one of the best nuggets in the last few years that I've learned from her in one of her lectures. We were at the San Francisco Public Defender's Office all training together, and she said this, and I remember going, oh my God, that's one of them. Because this is what we've always believed. If jurors say, I believe this, I believe in this, I believe, if you say, I believe, what about your conduct is consistent and models that belief? Or is it actually inconsistent? So you have a juror who says, you know, marijuana is just awful. It's the gateway drug to drugs. It shouldn't be legalized. It's the worst, blah, blah, blah. Okay? You got that juror, and it's a drug case. But what about if you learn that the behavior of the juror when they go with their buddy to Las Vegas is to get edibles? Because it's an awesome way to party when you're in Vegas. That's behavior that's inconsistent with their belief. It's super interesting. What about the jurors on a DUI? And this is one of the examples I think Sunwolf gave us, is, and I'm going to not make it perfect, but in a DUI case. And you got jurors who say they really are, you know, they think Mothers Against Drunk Drivers maybe has gone too far. They don't really like that. Are they a juror that has ever seen anybody on the road who and called the police because somebody was swerving? Are you somebody that's called an Uber for your buddy at one point during a party, or you taken an Uber yourself because you've been drinking? Find out what is the conduct that's consistent with their belief. What that means is that's talking to jurors. When you say you believe Mrs. Smith, can you give me an example of what you've done in the past that goes along with that belief? It's super interesting because oftentimes they get stumped because they actually don't have behavior that's consistent with the belief. They just want to say the belief. We see that again in a very divided country. Have anybody that said they didn't vote for Trump, but they went in the room and pulled the trigger, or I shouldn't say the trigger, but it's kind of a trigger to me. It is a trigger, and voted for Trump. But they said, I'm not going to. That's the expressing a belief because he's a bad guy, but their conduct is different. That's really, really incredibly important to you, right? Because you don't want people just saying it. You want to know what actually supports that belief. So that's, to me, really drilling down. Let angry jurors talk. There are a lot of angry people out there. People are really angry. It's actually scary to me how angry people are. And here's what I know about their anger is there's other stuff going on. People are angry for a number of different reasons. I may have been, said something jackass to you in line or pushed you out of line at the grocery store or been really rude. I may be angry for a reason. I don't know what's going on at home with this person. Is someone dying? Is there a kid in trouble? What are the other things going on with those jurors? So let those angry jurors talk. I think what happens is we shy away from the angry juror because we're afraid of what they're going to say to us, but it's okay. Mrs. Smith, it seems to me that you've expressed something that you feel really passionate about, and you seem almost angry. Can you tell us why you feel that way? Just ask them. Anybody else feel the same way as Mrs. Smith? Because there are a lot of us that agree with her. So I'm giving permission for other jurors to say that's okay. I'm not turning my back. I'm not shutting her down. I'm not judging. I don't judge in jury selection. I may judge in a lot of other things, but I'm not going to do it in the courtroom during jury selection, right? Because that closes folks down. So you want to make sure that you're letting those angry jurors talk. And I love it when they talk. I really do. It takes the heat off me. Let them all talk. Let them get mad at each other. That's okay. All right. So when I'm creating the questions, how do I create the question? How do I create that deselect question? And I want to identify the attitude, the opinion, and the value that's not consistent with my theory of the case. So let me take a super simple one. You got a sexual assault allegation. My defense is consent. That's an easy one. It's not ID, it's not he didn't do it, it's consent. So what I want to do is identify jurors who don't believe in consent if there's an allegation of sexual assault. Me too, jurors, okay, that believe the woman no matter what. That's the juror I want to identify and get rid of, right? Because if my theory is consent and that juror has a belief or conduct or whatever it might be that's inconsistent with that theory, there's no way I'm ever going to change their mind. What about if I represent one of these folks during the insurrection? They're one of the rioters. What kind of juror do I want? So my theory of the case may be, and I'm just saying, I'm not saying there could be a lot of different theories. My theory of the case may be that I was, what is my theory of the case in that goddamn thing? Theory of the case to going in and rioting is it was a mistake, I wasn't there. Let's say it's an ID case. I didn't go inside. How about that? I didn't go inside. I was in the crowd, but I didn't go inside. And nobody can identify me inside. So it's an ID case. So my theory is that I was on the outside and I'm not complicit. So what kind of jurors do I really want? I want kind of folks that thought it was public discourse, that this political discourse, that this is okay, that it's all right. And jurors that I want to deselect are jurors who thinks this is the worst thing that ever happened. It was the degradation of society. You're going against the law. This is not the right way to do it. That's the person I want to kick off. I want to deselect for. So, do I want Democrats? That might be in my profile of, I don't know if I want Democrats. Do I want libertarians? The political association may be really important in that case. It's not in all cases. Let me be very clear. It's not in every case. It's just like sometimes the racial composition in my jury may not matter in every case. Some people say, sure does. Depends on the case. So I will tell you, I'd love Republican Fox jurors on a rape case every single day of the week, okay? That's who I love. They're the best jurors. They scrutinize the hell out of the case. They don't like the government. And if you say anything about Obama being involved, your client's not guilty, trust me. Okay, all right. So I want the questions that the bad juror is going to answer, not the good juror. I'm not going to be talking about presumption of innocence and all of that. I want the question that the bad juror is going to answer. So if I get one question, so in federal court, I had a judge who said to me, I'm going to let you have one question. I'm like, okay, I can work with that. I can work with that one question. I had a client in a drug conspiracy from Mexico, and who spoke only Spanish. So we got a lot of issues there, right? A lot of, unpacking those layers is really hard. I got the interpreter in the courtroom. By the way, recognize the interpreter, talk about the interpreter. Everybody always acts like the interpreter's not there, that the jury's not going to see him, that your client's doesn't speak English. Really? Talk about it, okay? You got to talk about it. So my theory of the case was my client was involved in the conspiracy, which anybody who tries conspiracy cases, you know how hard it is to take them out. If they were standing there and they know the rest of the folks, they're in the goddamn conspiracy. It's the worst law ever. We've got to dismantle that law. Okay, so he was alleged to be in the conspiracy, low-level person. His wife was actually the queen of the conspiracy. It was super interesting. She pled out. Didn't flip, though. Took the hit. So I knew what the problem was in the case. So my only question to the jury when I stood up is, there are a lot of folks in this country who believe a wall should be built because of this very kind of conduct that involves individuals from Mexico accused of drug crimes. That's all I had to ask. And I'm telling you what, they were talking about it all day long. I deselected in about 5 minutes. I never got so many, they were just challenges for cause all over the place because I gave them the permission to agree with a theory that was inconsistent with my case. Because if you're a racist and you believe that the wall should be built for that sole purpose, then you gotta go. Am I right or wrong? You gotta go. You're never going to buy into my theory of the case that this person is innocent. So it was great. It was awesome. And it was hard. It was hard to stand up and have to do that out of the box. The one question, because you know the government got one question. I can't remember. You can be fair. You know how they do. You can be fair, right? I don't need to know anything because you all are going to be on my side. So, and then when you sit down, you got to remember, you got to let your client know what you're doing. Because the client feels bad when everybody doesn't like them. So you need to let clients know what deselection is, what that looks like, and bad answers are good answers, and be able to explain why you're doing that. Bad answers are good answers because I want this jurors off your case. Does that make sense to you all? You get it? That's what deselection is about. Bad answers all day long, okay? Now I can intelligently exercise.
The CLE verification code for this program is 2E4342. 2E4342.
Identify the attitudes, the opinions, and the values. Okay, how do you start out your voir dire? Okay, so I used to be really I used to say you can only do it one way or my way or hit the highway kind of deal. I don't believe that anymore. You do your own introduction. Here's how I feel about introductions, though. They need to be open and honest. You don't need to be talking about yourself. You don't need to be saying thank you. I don't understand that. Thank you for being here. You didn't have a choice. You got a juror summons. You have to be here, okay? So I don't get all these flowery, I don't understand it. But now this is what I do know. It's because you're nervous. You don't know what to say. You're nervous and you're trying to warm up the crowd like a comedian does, I guess. But you got to get into it. This is why we're losing ground on voir dire, is because the judges are like, why are you asking the question about someone's license plate or the football game or whatever it is? It's because we're nervous and we don't know how to get into it. You've got to feel righteous about it. I don't care what kind of case it is, okay? You got to get into it. I'm here today. This is a case about self-defense. You're going to hear that someone was killed in a bar, and it's going to be awful, and there's going to be a family behind me crying during this trial. I want to talk to y'all about who believes in self-defense or whatever it is. If you think that someone is drunk, do they have the right to self-defense? Does someone who's drunk have a less right than someone who's not drunk? That someone who's black have a less right than someone who's white? That someone is a woman have more of a right to self-defense than a man does? Those are all issues that could be in my case, right? And I'm going to deselect for it immediately. How about if I have a doctor that's accused of inappropriate sexual contact who might be an OBGYN doctor? That's a good one, right? Because you got an OBGYN doctor and, they're normally placing women in positions of power, of status, in terms of when we go in there. I don't care how tough you are, the woman that goes in to get her annual, we become like, okay, I'll get on the table, I'll do what you're telling me to do, because you're the doctor and you know what you're supposed to be doing, and that status matters. So when we know that in a case, those are the facts that we have a real instinct about, and you don't have to be a woman to have that. You have to be a man that learns about it and talks about it and is factually able to stand up in front of a juror. You got to talk about it with a juror. This is a case about a doctor who's been charged with inappropriate sexual contact. Some people feel like, yeah, if you're an OBGYN doctor, there's something about you that makes you a little creepy. That's what they do think. Why the hell would you want to be an OBGYN doctor opposed to being a surgeon or a podiatrist? How about a proctologist? Why the heck do you become a proctologist, okay? So I need to talk about it in a way that gets me there to a deselection question, in a way that's truthful and honest, right? So that's how you've got to do it, is tee that up, go right there, and these introductions and setting the tone and all that is important, but I'm telling you, in my experience, what's important is being honest with the jurors. I've had jurors tell me on many, many jury selections after the trial is done, and you talk to jurors when you win or lose, and frankly, you should talk to them when you lose. I know it's not as fun and it doesn't feel as good, but you need to talk to jurors when you lose, okay? It's good. It's good. You find out good information. But they always say, I liked you because when you stood up and talked to me, I knew you were going to be talking about something in the case that was true, that was credible, that you didn't waste our time. That's important. That's important. So getting that credibility is super important. So here's an example of educating the jury. The police know how, you would agree with me that the police know how to break down young, vulnerable children. Okay, that's educating a juror. But here's the deselection. No one would confess to a murder they did not commit. A lot of people think there's no way. If it's a confession, why would I ever say something that I did, particularly serious as murder, if I didn't do it? So I may have Richard Leo, I may have all the best confession folks in the world, but if my theory of the case is this is a false confession, then I better tee up the deselection to find out the jurors who are never going to believe someone would falsely confess. Right? That's the only question that matters. And I think often in cases, if you can get your jury selection down to that one core question, and then those other questions can flow from that, you got it going on, really. And it makes it super simple. Makes it super simple. So Here's what we call theme flipping. So it's using the government's theme and flipping that. So here's a theme that the government may have. Athletes play by their own rules when it comes to sex. In a sex case, you got someone accused, you know, a high school kid, college kid, NFL player, whatever it is, and they're accused. So a lot of people believe that athletes write their own rules. They can do whatever they want. People believe that, right? They do. You believe it. So why wouldn't they? So that's my deselection question. If I got a consent case or something like that going on, I need to get to the heart of it. That is the theme flipping, so using the government's theme and going right to it. If you sell drugs, you're ready to do just about anything to make a buck, make a dollar. Attitudes to about the criminal justice system. People who believe that not testifying means you're guilty of sin. So here's what we do. You believe that everybody has the right to remain silent, right? And the judge is going to give a jury instruction. If the defendant doesn't testify, the defendant doesn't have to testify. Everybody's going to go, yes, they can follow the law, blah, blah, blah. But what if they really can't? They can't. They don't believe that. They believe most often that if the client doesn't testify, there must be a reason. That's what I want to know. If I have a client that may or may not be testifying. Now think about this strategically. I never put clients on. I don't care what kind of case it is. It's just, I just don't do it. That's a control issue. It's worked for me. I win. So it's not everybody. I get that a lot of people like to put their clients on. If you're gonna put your client on, I think this is a really nice thing to do because you're deselected, but you've let people know, why people are don't. If you're guilty of sin, you don't testify, and then the client testifies. So you've put that out there. You've put that out there with the juries. It's kind of nice strategically, but it's also something that a lot of folks don't believe in is if you don't testify, you must be guilty. How about people who believe that police officers are more honorable if you need to confront an officer's testimony? Now, don't do this. Don't do what I used to do in every case as a young lawyer. I don't know what it was, but every time a cop came into court, I had to go after them. Even if it was irrelevant, had nothing to do with the case, it was a trigger. It was just a trigger. And I just couldn't, I took the bait. I would just go after them. So you don't need to do it all the time, right? Sometimes you don't ever even need to cross-examine them because what you have to keep in mind, what's consistent to the theory of my case? Is the cop's credibility consistent or inconsistent to the theory of my case? Is there something about the integrity of the investigation? Was there a compromise? Did the cop lie about something they didn't have to lie about? Does it matter to the theory of my case? Don't take the bait, know what it means, but find out from your jurors. If you have cop credibility, that's important. Some people say, you know what? In this day and age with defund the police and everything going on, everybody's against law enforcement, and we don't support them enough. How many of you agree with me? Do you see what I'm doing? I'm finding those jurors who believe in that so I can get rid of them. I need to exercise that preemptory. And it feels weird because I always bring myself into the belief. Some of us, I include myself in all of that. That's that giving them permission to answer it and that I'm not judging them. And that's also really important when you're asking these tough questions. And then people who believe, and I think Martine's going to talk to you a lot about the high authoritarian in race and jury selection. Listen, listen, listen. Don't talk. Don't interrupt. Don't talk so much. It's the hardest thing lawyers do. We're the worst goddamn listeners, aren't we? I mean, last night at the cocktail party, I was looking around. We're all talking at each other, blah, blah, blah. We love to hear ourselves talk because we're trial lawyers and we think we know a lot of important things. Sometimes we do. Sometimes we're super interesting. But when you're in jury selection, the juror is the most interesting person in the courtroom. It's kind of like that. What's the commercial? I'm the most interesting man in the world? Yeah, whatever. They're the most interesting person in the courtroom. Listen, listen, listen. Then ask these follow-up questions. Is there a particular reason that you feel that way? How long have you felt that way? If you're teeing up that challenge for cause, it sounds to me like you felt that way before you came here. Is there something that triggered your memory as to why you felt that way? You're building that record to make that stronger challenge for cause, and it's obviously for your preemptory in case you don't get that. This is the spectrum question about why some people feel that law enforcement is really under attack. Other people feel like, it's time to change things. I wonder, Mrs. Jones, where do you fall on that? Now, people that use spectrum questions, I feel like it's a lot easier. It kind of gives you a way out. You don't have to go right to the heart of it. To me, spectrum doesn't help me because it's just the way my brain works. Because if someone's a 1 to 5 and they say they're a 3, that's kind of meaningless to me. Really, it doesn't mean enough to me. But some people like that grading and that way to get to something. So if you're going to assign numbers, if you're going to do the spectrum, make sure you understand what that assignment means. What does that 3 really mean to you? So when you sit down and you look at your paper and it says 3, you know what it means, right? Compared to someone who was a 2 or a 4. But those are the spectrum questions. And then remember, you can thank and praise jurors and spread what we call spreading or looping the answer. So Mrs. Jones said, that the people in her neighborhood down the street, there are a lot of them living in the same house, and she knows they're not here legally, and it seems like there's criminal activity. A lot of us feels that way. Anybody else feels? So I'm looping her response, just like you would in cross-examination, to the next juror and asking them about the same thing. So that's the looping, and it's a really nice way to get jurors to agree with each other on something that you didn't put out, but another juror put out. It's that giving that permission. Thanking and praising jurors, be careful what you're thanking them for, okay? I don't really like thanking jurors because I feel like I'm very disingenuous about it. I'm really not thankful for your jackass racist statement. I'm not. But I'm glad you told me about it, right? So I can get you out of here. But that's a hard one for me, particularly if I have other jurors of color on my panel. If I'm thanking Mrs. Smith or Mr. Jones for being a racist, that's not going to bode well, even if my strategy is to open the door and not cause judgment. That's a place I can't personally go. So it's really, you've got to make the call that's good for you. The thanking, again, just seems so fake to me. It's just fake. I don't like to be fake. But do what is good for you, and if you have that personality, go with it if it works, okay? Don't argue with jurors. Don't act like they're your partners. No cutting them off, no interrupting, none of that stuff. If you interrupt a juror, let me tell you, that's it. You're done. You're done with that juror. They're not going to forget that. But remember, here's what we're working for, right? We're getting to the not guilty. So I had jurors picked out here. I had 4 jurors that we were going to do a little bit of jury selection. Here's what we're going to do if you're around. I'm available to talk to you about going to these jurors. We were going to have 4 jurors that were going to be like bad jurors for us that I was going to show you how this really works, because I don't want you to think I just talk about this. I'm doing it, okay? And sometimes it's really, really hard. It's really difficult when you get that one question. But then I had Judge Thompson in Alabama, and I don't tell stories, but I'm going to tell this story because it was remarkable. He said to us, when I asked for attorney-conducted voir dire, he goes, okay, I'm going to let you have it. And I thought he was going to say 5 minutes, because that's what they always say to me. He goes, I'm going to give you unlimited time, Miss Wayne. There were 3 other defendants, defense lawyers, and the AUSAs. They all passed. I was the first one to get up with a cold panel, about 150 people in a big old room. That's scary, right? That's a hard deselection, because you're like really trying to be tuned in, and you're on, and you're the only one going, and you're trying to find out. In this particular case, it was a drug case, so all those issues about drugs. But sometimes you'll get judges who are okay. It's the one and only time in my life I got a Batson challenge that was actually granted. And I always thank Judge Thompson for doing that for me, even though the rest of the trial was fucking miserable. This is the best part about a case. Do not let them take this power from us. I'm begging you. This is, you cannot let them eradicate this, because this sets us up for real justice for our clients. So be comfortable with it, enjoy it, but make sure you're getting to the heart of what really matters, and that's getting the not guilty for your client. Thank you.